So I want to talk a little bit about his legal accomplishment, which Procopius, a man who would be familiar with law courts, with legal systems, doesn't tell us anything about in his works, virtually nothing. Justinian essentially codified the Roman law. And this is important not only because it's the basis of European law, but law is related to political and administrative order. However much we may hate bureaucracy or denounce administration, that is how governments provide whatever it is they are providing for their citizens. And since the alternative to government is anarchy, and since there are examples before our eyes of anarchic societies, it won't do to underestimate the benefits of law, however cynical we may be about its implementation. Roman law at the time of Justinian was, as law tends to be, learned and unwieldy. If you wanted to know how to resolve a question, you could go through the thousands and thousands of what are called responsa, or you could look at legislation. Just as in the Anglo-American tradition, and some of you will learn this very soon in law school, you can either look at statutes passed by legislatures or court cases, precedents. The equivalent of a statute, Connecticut passes a law saying that you can't have a gun in your car, whereas Texas has laws that say you can have a gun in your car under such and such circumstances. Okay, so you have a whole set of statute law, which would be imperial statutes in the Roman Empire, imperial legislation. Or, if the statutes don't cover a particular situation, or you want something that has the particularity, a tree on my property falls on my neighbor's, did I mention this already? Yeah, that one, on my neighbor's garage. Who's to blame? Okay, you go and you say, well, this case came up in Cincinnati in 1949, and this is what the judge found. In the absence of computers, the search for this stuff is very hard. In Anglo-American law, this is called precedents. In Roman law, they're called responsa. And interestingly enough, this term is also singular, plural, applied to Jewish law. A response is a response. A judge, an expert, a law professor, in effect, is asked his opinion on something. And his response becomes preserved as a kind of precedent. These were voluminous and represented centuries of law, and even more, of course, the responsa conflicted. One judge says, you have to pay because it was your tree. Another says, it's an accident, he's responsible for his own remedies. What do you do if you have a conflict of judges? What if you have two kinds of contradictory responses? You've got to decide who is more authoritative, which one is better. So the work of Justinian's compilers was to sort out legislation, statutes, and the responses, and also to decide among contradictory ones. What is in this law? Well, what's in any law? We think of law as having mostly to do with criminals and stuff like that. But criminal law is actually very simple. It's like the Burgundian Code. If you murder someone, this is what's going to happen to you. There may be different kinds of killing. If you murder them with intent and premeditation, that's worse than if you murder them in a fight and spontaneously. Manslaughter is different from murder. Manslaughter is where you didn't intend to kill the person, but you did. You punched him and you didn't know that he had a weak heart and he died. That's manslaughter. You punched him. You intended to hurt him, but you didn't intend to kill him, but he died. vehicular manslaughter, you know. What's the difference between negligence, you should have seen something and you didn't, versus criminal intent? You did it deliberately. But it's very simple, the criminal law. There aren't a whole lot of gray areas, and you can get through the criminal code pretty quickly. But what about contracts? What about property? This is endless. This is endless. So, you know, in law school, criminal law will be, you know, the cream or the tip of the proverbial iceberg, or some little side issue. Most of your time is going to be spent on, those of you who go for this option, on you know, property and contracts. And that's what the Justinian law is mostly. Property and contracts, legal arrangements for buying and selling, inheriting, partnerships, guardianships, security, surety, obligations. This is a very advanced science in Roman law, as advanced as it is anywhere at any time. This is very different from you cut off one finger, you pay 5 solidi, which we were looking at last week. The work that ensued, the so-called Justinianic Code, or the Corpus Juris Civilis, the body of civil law, was drawn up in 5 years. Here again is an example of unbelievable rapidity compared with the length of time it takes now, you know, merely to reform the Connecticut tax code, or the Connecticut traffic code, for that matter. It was undertaken by a commission. 4 books were issued. The first is a collection of statutes, and it's called the Codex. Collected laws of the Senate and imperial laws of previous centuries. The largest book is the Digest, or in Latin, Digesta. The Digest is the weeded out responsa, organized by subject. So this would be where you would go to try and figure out what happens if a river changes its course a little and your land seems to be now taken over by your neighbor. Is the river the border, or is a line, an artificial line, the border? The third book is a kind of textbook, or a survey of the whole law and what it's supposed to mean, called the Institutes. And the fourth is called the Novella, or New Laws, because obviously new laws would have to be made. The Codex, the Digest, the Institutes are in Latin, because Latin was the language of the Roman Empire. But the Novella are in Greek, because Greek was the language of the empire now being 534 when this work was finished. The Justinianic Code is more, however, than a rearrangement of old laws. It displayed a consistent philosophy of government. Where law is more than precedent, it is an active force in society. The emperor is seen as the servant of the law, the implementer of the law, but he's also the master of the law. He is an absolute power. He is the embodiment of the law. This is a well-run, immense, burdensome empire. Procopius gives us, unreliable though he may be as to Justinian being a demon, etc., Procopius gives us a vivid picture of a highly governed, even efficiently governed, but oppressively governed, and very ambitious society. Now, for next week and a little bit after, remember we have no class on Wednesday, we have class on Monday. You're going to read from Gregory of Tours, about Clovis and the Franks. And it will seem more violent and more primitive than what we've been reading. But violence and primitiveness, unfortunately, are part of history and government at almost any time. So enjoy the intrigue. I'm not going to test you on the names. You'll see there are lots of great cat names of the Frankish barbarians. But pay attention to the figure of Clovis and to the attitude of Gregory. Because as with Procopius, we've got an interesting, if not completely reliable source.